Hello. It's my pleasure to moderate this discussion of employment arbitration. We have two terrific speakers, both of whom are Cornell faculty. They're renowned for their research and teaching on the issue of employment arbitration and all. Before I introduce them, let me set the context for this discussion. There's two key phenomena about employment arbitration. One is that it's grown enormously in the United States, thanks to the evidence that Alex Colvin has provided through his surveys. We now know that more than 50% of eligible individuals are covered by an employment arbitration clause of one sort or another. And the second key phenomenon is that it's an extremely controversial procedure. There are those that think it's a denial of employee rights to be forced into this procedure, and others think the procedure can serve useful purposes, and in particular can allow individuals with smaller claims, for example, to get access to a review that they might not otherwise get in our system. The two great speakers we have are Alex Colvin, who's Dean of the ILR School. Alex is also, of course, a professor at ILR. He's an active participant in the Scheinman Institute on Conflict Resolution. Dave Sherwin is the other speaker. Dave is a professor at the School of Hotel Administration. That school is now a part of the Johnson College of Business. Dave has also done extensive research and teaching on this subject. He also serves as the director of the Kyler Center. And in that role, he has brought together labor and management and plaintiff attorneys and other advocates to talk about employment arbitration and see if there's some kind of policy that all the parties might agree to and find better than the current system. Well, let's just get into it now. And what I'm going to do is pose questions to each speaker and then allow some give and take about those questions, and then eventually open it up to questions from you all in the audience. So my first question, and I'll turn to Alex first for this, is what do you think are the strengths and weaknesses of employment arbitration?
So I think the strengths and weaknesses really come out of attention back to where this whole employment arbitration thing came out of. There was really two origins in my mind that really date back to the 70s and 80s and 90s. And it was really the 90s where this stuff originated in the employment area and became much bigger over time. But there was two things. One was a movement back in the 70s and 80s, the Alternative Dispute Resolution or ADR movement, which was an attempt to use tools like mediation arbitration to come up with both simpler, more efficient, but also better resolution of conflicts and a reaction to the American complex legal system. And so certainly that was part of the origins of it, and that's where you see the more positive arguments for employment arbitration, the concerns about the time and the expense of litigation. The other part of it, though, I think, is the reaction to the rise of individual rights litigation. So litigation just isn't about any old thing, it's about specific things. And if you look over time, there's been an expansion of employment rights in the workplace. Litigation in America is the mechanism we use to enforce employment rights. And particularly when you get into the 90s, you get some changes in the law, the Civil Rights Act of 1991, the Americans with Disabilities Act of 1990, the Family Medical Leave Act, that helps supercharge litigation. Litigation becomes bigger in the employment area, damages are getting larger, companies are under more pressure. And that's a key part of it. Companies reacted by trying to protect themselves by putting in place mandatory arbitration agreements that employees had to agree to. And I think that's a core part of the weakness, right? If you think that these rights are things that were being established to protect employees, this is a reaction against that. And so I think that tension runs through the whole area. To my mind, there's really three main sort of lines of critique of mandatory arbitration, this thing we've seen grow in the last few years, last couple of decades. One is sort of a principle level critique, saying that what mostly happens is an employee is presented with this take it or leave it condition of employment. You have to sign it if you want a job. You have to agree to arbitration disputes. And people react against that, that this is imposed on employees. And it's not like the alternatives. In the unionized setting, we have bilateral negotiation by union and management to come up with arbitration. This isn't like that. Employees don't have that voice in creating the system. And so that's one of the critiques of principle. And it's also not like a public system. You could imagine a public system of arbitration that the government said. It didn't really happen like that. It was kind of a quirk of litigation and some Supreme Court decisions. We never really had a public buy-in for this system. So that's sort of the principal argument. The second line of critique is really around due process, that some of these procedures aren't fair. I think, that particularly in the early days was one of the strongest critiques. There were a lot of unfair procedures. People would cook up a procedure with various due process violations. A lot of companies, I think, have moved away from that. If you look at who's doing it now, I think about half is done through the American Arbitration Association, another quarter through another major group, JAMS. They have pretty good due process protections in their procedures. There's another 20% maybe who are doing it on their own or through other agencies. There, I have more due process concerns. I think that's kind of more the Wild West. But there's a couple of big due process things I hear a lot that are broader concerns still. One is around discovery, that you just don't get as much discovery before trial the way you would in litigation. And plaintiff attorneys regularly tell me that's one of the biggest due process concerns they have. The other one that's really controversial recently is that you can put class action waivers into your arbitration agreement and knock out class action lawsuits. And that's very controversial. And I think that's a major due process issue currently. I guess the third and last line of critique really is, though, around impact of the outcomes of arbitration. This is where a lot of my research has been, finding that the outcomes for employees are just not as good in arbitration as they are in litigation. They're much lower. If you combine together win rates and damage amounts, the outcomes are a lot lower for employees. That is an advantage for the employer. It means less pressure from litigation, but it means less returns for employees, and it makes it harder for plaintiff attorneys to finance cases. They finance cases on contingency fees. They can't make enough money to bring cases, so there's less access to justice, and that's really one of the most unfortunate outcomes of this, because part of the core idea of ADR is to provide more access to justice. So, if you have an ADR system that increases access, that'll be good. The problem is it doesn't seem to be working that way, and that's for me probably the greatest weakness in the current system.
So just a brief follow-up, and then I do want to go to Dave. So I understand your criticisms, but I also hear you say that it might be possible to construct employment arbitration in a manner that where there was due process. We'll get into that debate on the policy side a little bit later, the specifics, but it sounds like you're saying that there might be something healthy about employment arbitration if it would improve access, if it was done in a way that would improve access, right?
So arbitration isn't inherently a problem as a tool, right? We use it in labor arbitration all the time very successfully between union management. Executives do employment arbitration all the time. And I've got some research showing that works quite well for them. They're sophisticated parties. They've got strong representation. And I think arbitrators, frankly, can identify with executives more than they can with lower level employees and tend to be more favorable to them. So you can have settings in which it works. It's not arbitration per se that's the problem. It's the way the current system is structured.
Mm-hmm. Okay, and we'll get later to this question about what each of your advice about how to change the current system. But now let me ask Dave to his response to this same question, strengths and weaknesses, and then I'll allow a little bit more tit for tat back and forth over your various views. Dave, go ahead.
Well, thanks, Harry, and thanks, Alex. And before I start, it is a thrill to be on a webinar with a current ILR dean, a former ILR dean, being an ILR grad, and we're talking about a subject that was near and dear to the heart of David Lipsky, another former ILR dean. So it's really fun to be here. So thanks. Going off what Alex just said, and he had his 3 topics, the mandatory nature of arbitration, and I think that's something that's worthy of discussion. I do agree with what Alex says, that it feels wrong to say this is the way it's going to be. My counter has always been, hey, there's a lot of things in the employment context that are the way they are because of the company. You join a unionized company, you're a union, you're part of a union, you're covered by a collective bargaining agreement, you have to pay dues. That's what happens when you decide to be a public school teacher in New York City. That's the way it is. That's if you go work for GM in Michigan, that's the way it is. A non-union company will tell you how many vacation days you get and what kind of health insurance you get. There's a lot of mandatory aspects. When it comes to people's rights, it's worthy of discussion, and we can get into that later. But I don't think it's so 1-0. There is a thought with it. I do agree with Alex that due process was a major concern in the early 90s. The term, I think you just used it, Alex, the Wild West, and we've used it before. And there was always that case that everyone always cited where there was an arbitration policy from Pony Express somewhere where they, the damages were limited to like $2. You couldn't bring a lawyer, and the arbitrator was the sister-in-law of the owner. It was just absurd. That's, for the most part, been corrected through court cases, through the due process protocol. We've covered a lot of that. The discovery issue that plaintiffs' lawyers raise, that's the point. And that's where I'm going to move on to in a second, which is there is limited discovery in arbitration because discovery is what drives the very high costs of litigation. And they make litigation really for only high salaried employees or egregious employment decisions. And when we have extensive discovery, plaintiffs' lawyers won't take cases, employers don't take cases, and so on. So the limited discovery is a double edge. On the one hand, it makes it difficult for the plaintiff in some ways. On the other hand, it allows this actually to get your day. And then the last thing, well, actually, class action waivers is something that Alex brought up. I think it's a huge topic. And it's kind of beyond we could talk about it for the whole hour. So I'm going to accept that it's something we need to discuss, but not now. But the last thing that Alex talked about was impact with win rates and less action to justice. And this is my biggest complaint with there are 2 sides to this debate. Alex and I are on different ones, and we've enjoyed going back and forth for years. But the impact, I find that when we talk about it, we're looking at the wrong subjects or the wrong data. We're looking at trials, trial verdicts versus arbitration awards. If you look at cases filed with the EOC, my research has found 0.37% of the cases are actually going to a verdict before a court. And they're not random. They are cases that, for the most part, are somewhat strange, that nobody got around to settling, mediating, and so on. And there are more than 100,000 cases a year that are in the litigation agency system that we never talk about. But if you look at EOC data, their merit resolutions are below 20% of all of their resolutions year after year. And when we combine EOC data with litigation, with arbitration, the argument that arbitration is less plaintiff-friendly seems to fail. And when we look just at litigation, if we include motions, summary judgment motions and motions to dismiss, we find that plaintiffs do much better in arbitration than they do in litigation. It's just when you take, and Alex and I have both done this research and cited Laura Beth Nelson's work, when you take 38% of the cases, all losses, out of one side but not the other, that leads to what I think are inaccurate results. So I would argue strongly plaintiffs do better in arbitration than they do in litigation.
So let me just follow up a little bit, Dave, and then I'll let Alex respond with statements or questions. Could you explain a little bit more about the EEOC channel? You're introducing this other form. Normally we think, oh, you can go to employment arbitration or you can go to court and litigate, but you're reminding us all that there's this other channel. You can file a complaint, the EEOC may pick it up. Could you just explain a little bit more about the EEOC and how it works before we get, just for not only me, but others in the audience that may not even be familiar with that channel? Then I'll turn to Alex for his reaction.
Absolutely, and thanks. And before, as I begin, because we work with a great university and we have a great address, we've interacted with the former general counsel of the EOC board members, commissioners, and I truly believe that these folks are so strong to protect the rights of employees. So it's not a criticism of the EOC and of its people, because I have the highest regard for them. But the way the EEOC works is, before an employee can file a lawsuit, they need to file a claim with either the EOC or, if their state has a state law, which almost all states do, Georgia, North Carolina come to names of states that don't. So you can go with the state agency or the EOC, the federal agency. They're cross-filed. And then the EOC begins an investigation. And the investigation, a statement of position from the employer, a fact-finding conference, a whole lot of stuff. It can take as long as a year just to get an investigator assigned. And the EEOC labels cases A, B's, and C's. C's, they don't even talk about. They just say no action is required. Those are 20% of the cases. They just push them aside. A's are part of their national enforcement plan, but they don't have the resources to truly enforce them. So they will litigate fewer than 200 a year, even though there's close to 20,000 or 10 to 20,000 of those per year. And the rest are the B cases, and they go through this long process where from day one, they try to settle. At the end of what can be years, they will, if they can't get a settlement, they will issue a right to sue letter. They will issue a finding. We find probable cause or no cause, and then they will give you that letter, the right to sue letter, that allows you to go to court. If you are a high-end employee and you have an attorney, after 6 months, you can demand a right to sue letter and you will get one. And some lawyers will ask for them earlier, but the EEOC process is a long process. And then the last thing I'll say is, I found the process so inefficient and so unjust from both sides when I was a practicing lawyer that it drove me to begin to explore arbitration, because I had clients that did not violate the law who settled because the costs were so much. And I had clients that violated the law, and we used that process to make it go away or settle for next to nothing. And so the process, to me, is extremely unjust, and that's why a different way has always been the driver of my academic work.
Okay. So, Alex, now I'll call on you to respond to anything Dave said, or just some additional points you want to make regarding strengths and weaknesses.
Well, I'll start saying I am actually going to agree with the idea that the public agency reform is something that really should be taken in hand. This has been something that I think as a country we're bad at, is regularly updating and reforming our public agencies to make sure they're working well and working well for both parties. I think this is one of these areas you get surprising consensus, I find, talking to both plaintiff and defense attorneys. None of them seem happy with how the agency is working. And, so I think that is an area that there could be a really good reform agenda. We do also want to think, though, as well about the state agencies, that depending on the state, we've done some research indicating, how large the differences are in the role of the state versus federal agencies, depending on the state you're in. So, somewhere like California, the state Fair Employment Practices Agency is a much bigger player relative to other states. So you have to think about that as well. In terms of what that means for arbitration, I'm not as convinced that this actually makes the case for arbitration. If you look at the outcomes, the number of cases filed who actually get filed in arbitration, get to hearings in arbitration, is remarkably low. It's like a 5 or 10% of what you see in the courts in terms of numbers of cases. And so, even if the EO is slowing things down to get to court, it still seems the case that way more people are getting to court than to arbitration. So empirically, I'm just not really convinced by that. There's some tricky things, just in terms of the measurement stuff. The settlement and preliminary summary judgment motion issue is one of those interesting technical ones to work through, and I've done some work trying to work through that. It's actually a tricky one because there's some interesting studies showing that you get a lot of settlements after summary judgments. So summary judgment can do two things. It can knock out a case because it's too weak, but if you get through summary judgment, you actually tend to, as the plaintiff, settle for relatively high amounts. So that those cases disappear in settlement, but they're actually plaintiff win kind of cases. So the summary judgment story looks a little more complex when you analyze it. Settlement's also a huge part of it. Settlement's a huge part of arbitrations. So we find that over 2/3 of cases settle in arbitration as well. And what you do in settlement depends on what is the outcome of the cases, right? So you have to look at the trial and the hearing outcomes to understand what the pattern's going to be in settlement, because you settle in the shadow of the outcomes. So, I think settlement's important, summary judgment's important, but they're all occurring against the backdrop of hearings that are producing lower outcomes for employees, right? I still think if you look across all the evidence, it just keeps indicating that you get lower outcomes even when you try and peel it out different kinds of ways. So I retain my skepticism, I would say, on the positive outcomes.
I'll go back to Dave in a second. I just do want to add that I would assume both of you would agree that having settlements isn't a bad thing, as long as there's due process and as long as the parties aren't settling because they're fearful of a really draconian outcome. But the data showing high settlement rates, that may be that mediation and discussion is actually working. In conflict management, we often talk, you'd want to solve problems close to the source. And again, with a good system that has due process protection and an appropriate threat point, whether that's a judicial threat point or a binding arbitration threat point, having high settlement rates actually may be a sign of health in a healthy system where the problems are getting resolved close. My own data, and Alex mentioned it, in collective bargaining, there's very few cases where there's written grievances that actually end up in arbitration, and that's because the parties are resolving those issues in a healthy way with a duly elected representative of the employees, as Alex points out. So there you do have due process protections, and the fact that you have really high settlement actually may be a sign of health rather than not. Anyway, let me go back to Dave to see if he has both comments on any of this discussion or wants to add some more points about strengths and weaknesses. Then I'm going to move on to the policy question about what each of you thinks should be done. You've begun to mention that a bit, but I want to turn to that. But anyway, go ahead, Dave.
Yeah. Thanks, Harry. And to go back and forth with Alex again, as we've been doing for 2 decades on these issues, I disagree on the argument about the summary judgment motions for a couple reasons. First, there's a threshold issue that we need to discuss. We're talking about what's more plaintiff friendly, what's not, as opposed to what's more just, because we don't know what percentage of cases employees should win. Should they win 50? Should they win 90%? Should they win 10%? We just don't know. So the general rule, and I'll let Alex, or hope Alex will either agree or correct me. When we look at the research, you're seeing a 25% or so win rate in arbitration for employees and about a 33% in litigation, give or take. I think that's kind of where we are on the numbers. And if the data sets were perfect and those were our numbers, 33 versus 25, we don't know what's right. We know what's better for employees, but we don't know what's right. And maybe 25 is right, maybe 50% is right, and we're way off. So that's one problem. But the settlement issue that Alex brought up with how summary judgments lead to settlements or not, In his data set that he used in one of his articles, he found that the cases in arbitration settled 58 or 59% of the time. And the litigation data that we both have relied on found almost identical settlement rates in litigation. I have a AAA data set where 75% of the cases settled. So that to Harry's point, seems like a better outcome. Settlements, if settlements are good. We don't know how many cases were filed with employers that went through their almost grievance-like procedures that never made it into arbitration. So, as Alex says, where were all those cases? Maybe they were all resolved, or maybe the employees felt it wasn't fair and didn't engage. We just don't know what the answer to that is. So we can't really comment on it. But the concept of taking 37% of your cases that are losses and knocking them out because surviving summary judgment may lead to settlements doesn't seem to me to justify it. But it's not just summary judgment motions. In that study that we both rely on, half of those motions were motions to dismiss, which are before anything happens, before discovery, where the employer says, even if everything the employee alleged is true, this doesn't violate the law. That knocked out 18%. We don't have anything close to that in arbitration. The most that we've seen is about 14%, and those are conflated with when the employee walked away. So at the end of the day, using motions or excluding motions gives us a very skewed idea of which ultimate verdict or award is more employee friendly, and we need to include them, is my opinion.
Okay, I'm going to let Alex respond and then go on to the policy question about what would you recommend as adjustments in the U.S. system. Go ahead, Alex.
Yeah, so I think that it's an interesting question of what the sort of right kind of win rate and right damages amount, average damages amount is. It's complex to calculate out, partly because you've also got to include state courts. Interestingly, federal courts employees do not as well compared to state courts. As you say, federal is about like that 1/3 employees win. If you look at the state court data, it's more like half, right? State courts are more employee friendly, and there's been some interesting research, I think, showing that federal court judges are not particularly labor friendly. But I think that's only a partial story, because I think state courts and state juries are much more employee friendly, and you certainly see that the more employee friendly states like California are very state court centric in terms of their systems. I do think, going back to Harry's point, that we do want settlement, right? Settlement generally is good. I mean, I think there are the rare cases. There's a famous article against settlement by Owen Fiss, which makes some good points, and certainly I don't think we want Brown versus Board of Education settled, but for most of us, we're not in that situation, right? Most cases we do want settled, right? Settlement is better for most people than going to a hearing or a trial, right? Arbitration or litigation, we'd rather have settlement. I mean, and that's why, I think mediation in any good system should be in there. That's a really essential tool and one of the great successes of ADR. I do think, going to a point Dave mentioned, the internal grievance procedures in companies are things that have not gotten nearly enough attention. Both he and I have written at different points about them. And I think that actually is where there should be more attention paid if we're thinking about how to design a really good system. We want to encourage more of those, because the reality is arbitration and litigation, when I look at both of them, almost all the cases involve people who've had their employment terminated. People do not get to continue their employment if they get to a hearing in either arbitration. I've seen plenty where there's an internal complaint and the company goes, oh, okay, yeah, I think we got this one wrong, and somebody gets to keep their job. So I think those internal procedures, which are different from our somewhere where I think there should be more of an effort to encourage those.
Okay, great. So let me move on to the policy debate. And just to remind the audience, employment arbitration is now on the policy agenda. There's the FAIR Act, which had been drafted in Congress. That there's now hearings in the Judiciary Committee about employment arbitration. There's a provision in the PRO Act. Both the PRO Act and the FAIR Act have provisions, I should point out, that would get rid of employment arbitration. And even more broadly, this is an issue which seems to be coming to the fore. We're not quite sure exactly where it stands on the Biden administration's agenda, but it certainly is one in which there may well be extensive congressional discussion and debate, and maybe a bill will surface. So let me first turn to Dave. If you're a master of the universe, what's your policy advice? What kind of system would you prefer and believe we should move to in the United States?
Well, thanks, Harry. And before I get there, I just want to highlight something that Alex said about two things. My point about how many of these cases are resolved early. Alex is right on point that almost all the cases that we see are termination cases. We did a study in the early 2000s or mid-2000s of a major employer where we studied all of their cases all the complaints that went into their system that ended in arbitration. And we found that 90% of their complaints or grievances were resolved in a week or less, and more than 90% of the employees stayed employed. And so we called that a huge victory. And I think that if we look from a policy standpoint, what is ideal? What is ideal is solving the problem, making sure it doesn't happen again, and keeping people employed so that because it's not good for society if people are fired and spend 3 years in litigation to get the money back, and lawyers and courts and all that kind of stuff. So our best thing to do is to resolve disputes quickly, fairly, efficiently. And so that segues into my policy. I don't think that our state and federal agencies, and I know that our state and federal courts are capable of efficient, timely resolution. I do believe arbitration or ADR is, but I agree with many of the points or the concerns Alex has. So what I think we need to do is fix our arbitration system with a bunch of standards not developed by a protocol, not developed by case law, but by legislation that says you want to do arbitration, you want to do ADR, this is how it has to be done. I'm not so hung up on mandatory versus voluntary, but I think that what we should do is use it as a vehicle to get rid of employment at will. We're the only industrial country that has it. It's time to say enough. We don't fire people, most good companies, just for fun. So let's say ADR, we have ADR with arbitration in exchange for you can only be fired for cause. And then what I would do, because Alex raised a really good point about Brown v. Board of Ed, we don't want that to be settled. We should let employees know that if you think your case shouldn't go through this ADR process, it's really important for society, give it to the EOC. And the EOC will have 30 days, 45 days to decide if they want to litigate the case. And that's the cases that fit into their national enforcement plan and make law. The EOC is the reason that we have Bostock and why transgender and sexual orientation is now protected under Title VII. That was their push. So let them do that. But the garden variety, he said, she said, or the termination wasn't fair, or was it this, that's better for ADR. I would require that every ADR policy have 3 or 4 steps. Grievance-esque meetings with the supervisor or HR, a peer review or a higher level review, internal mediation, maybe either way, external mediation, absolutely, and then moving on to arbitration. Arbitration, I think both Alex and I have found that arbitration, while it's getting longer, is still significantly shorter, quicker than litigation. Even those processes are done in 9 months as opposed to litigation, which is north of 2 years generally. So I would sit down with a bunch of stakeholders and say, let's develop this from scratch and let's get a fair system to resolve disputes with our goals of keeping people employed, making sure employers don't engage in conduct that is unlawful, and making it so that the law can develop.
Okay, thanks, Dave. Alex, your views about what the system should be.
So I'm going to suggest, I'm going to build off some of that, but with a slightly different perspective. But I think, some commonality there. I do think we need a public policy design process where we actually try to come up with a good system that will service the public, include both employer-employee constituencies, with the government through legislation actually taking a hold of this. We, as I said at the start, we have very antiquated agencies, models that date back to the 60s or in some cases the 30s, and really have not been updated substantially as the world's changed. If you think about something like arbitration, I do think the current mandatory arbitration, the thing that's caused this kind of fundamental rift is that you don't have buy-in from both sides. One side's been working on developing it. The way to deal with that differently, I think, is to have a public agency that takes the lead. You could imagine borrowing from examples from other countries that have arbitration-like systems overseen by public agencies. The Canadians do via human rights tribunal systems, which are essentially a public arbitration system. The British have an employment tribunal system that looks a lot like arbitration, not exactly like our arbitration, but in many respects similar. We could have a public agency overseeing it. I think that a public framework is really central. You could have a tripartite type of system, right, where there's employee and employer side representatives involved with the public represented as kind of the neutral in the middle there. I think that would be one key part of reform. I do think one of the tricky issues is this question of the tension between the sort of routine day-to-day cases and the really big, Brown Board of Education, but the equivalents in the employment realm. The really high profile, the Harvey Weinstein kind of sexual harassment cases, which I think it's going to be hard to say how those don't end up in the courts, right? They're of sufficient public concern. Dave mentions, one option, which is have the agency take them. Another is an option where you have to go one route or the other. The British have this kind of choice where you have to choose between the tribunal route or the courts route. And there's limitations to the court route. It takes longer. It's slower. It does have unlimited damages. The tribunals have limited damages, right? And so you could imagine a sort of bifurcated system that way, sort of a mega small claims court for routine employment cases. But you pick your poison, right? Depending on what kind of case you have. So I could see that being something that would work.
So let me go back to Dave, but I want to encourage you to give short answers at this point because we've got a number of questions from the audience that I want to turn to, and during your answer to those, and then as well maybe some additional time we'll return to this policy question. But I just want to see if Dave and then Alex have quick responses to each other's comments on the policy side. Dave.
Very, very quickly, I think that I agree. I think Alex and I were pretty much in agreement on a lot of the aspects of what, if we were master of the universe here, on what we would create. I am okay with sort of the private system, but I want the policies to be EOC or government approved, and the arbitrators to be part of the AAA or JAMS, because I'm concerned of us trying to blow it all up and starting all over again, because I just think it's unrealistic. So I'm staying within the framework, but it has the protections that Alex put forward. I just think that where it's difficult when Alex brought up the fact that buy-in, it's an interesting question on whose buy-in we're talking about. As a former practicing lawyer, this is an industry, it's a career for many, many people. And when we say we're going to get rid of, the vast majority of employment litigation, that puts a lot of people out of business. And so, but I think if you talk to employers and employees, about how they would like disputes to be resolved. They would like it to be streamlined and done in a less formal, fairer way and not be in litigation. But there's an apparatus or a machine that really likes litigation.
Okay. Alex, any quick reaction before I turn to some of the questions? And as you'll see, some of the questions drive us back to policy ishes. Alex,
no, let's go to the questions. Yeah.
Okay. All right. We've had a series of good questions. Two of them involve the Me Too movement and sexual harassment. One just asks, how does this issue come up, and how does your system design deal with issues of sexual harassment? And the other related question is, what about this question about confidentiality? And is there something wrong in the current system in which many potential plaintiffs and grievers are constrained by confidentiality requirements? So who wants to go first on that? I don't know.
I'd love
Dave and
yes,
okay,
I'd love
Dave
to.
and
So I think that Me Too is a great question because and the reason I volunteered is it fits into my argument. There's no law against sexual harassment. Sexual harassment is court created. It was discussed by an academic in the 70s, coining the term. And in 1986, the Supreme Court held that the term "because of sex" prohibits sexual harassment. And that is the perfect vehicle for litigation. And I believe that in a system where the EOC had more resources to litigate, that they would look at that as part of their national enforcement plan. And the Me Too issues would have been the cases that the EOC would take, because the cases would have, before arbitration, would have to go to the EOC. So I think, right then and there, that kind of fits into what we need to do with regard to Me Too. And what was the second part of the question?
Well, the confidentiality.
Oh, confidentiality. Confidentiality is a really interesting one, because it is really rare that either side on the parties want things to be public. Employers don't want it to be public, and your normal 25 to 40-year-old who wants to have a career really doesn't want, every time they get Googled, that they are the person that sued their former employer. It's just not a good career move. So the question is, how do we get the public to know about bad things without preventing employees? And we've all talked to people who felt that they were discriminated against, but they said, I just can't do this because the world will know. So the answer is, it's either the cases that the EOC takes, or we have some sort of situation where both parties agree, or the winner or the loser can agree, or the plaintiff can agree only if they win. There's something to be said for that. The employer says, hey, look, I don't mind if everyone knows when I lose, but when I win, that's on page 25, but the lawsuit's on page 1. So we can work through confidentiality, but it's something we need to discuss.
Okay. Alex, do you want to comment on that? I do have a couple of questions I'm going to turn to you next, Alex, that have to do with unions and all and the system. But go ahead if you want to comment on Me Too and confidentiality.
I just say, I think the fact of the plaintiff interest in confidentiality there is part of why you see mediation being particularly effective in sexual harassment cases, because both sides often want some confidentiality. I do think the kind of reaction against some of the kind of enforced confidentiality is because of the need to keep that the potential for the publicity, right? The reason that you make the big settlement in mediation is because the employer doesn't want their dirty laundry being aired, and so I think you do have to kind of make sure the mechanism's still in there, that there's that threat there that things could become public and it could become a bigger hit. That's what keeps the employers honest in those situations.
Okay, so now, Alex, there's two questions posed relating to unions, one relating to something you said, and it is, why is there a positive view of the grievance arbitration system that's used within the unions, that's part of collective bargaining agreements, versus the current employment arbitration system? What's so good about the grievance arbitration system?
Yeah.
And then the second question related to unions while you're at it is just what do you think if there was widespread adoption of the just cause clause Dave suggested in exchange for a voluntary acceptance of employment arbitration, would that reduce the demand for unions? Would unions face an existential crisis because people were getting just cause without necessarily getting a collective bargaining agreement?
Yeah. So on the why it works for unions, it's a jointly negotiated system with mutual agreement that the labor arbitrators are trustworthy and a professional cadre of labor arbitrators. I think so. You get that mutuality. I think a big part of that is that the alternative is the strike. Right, the threat is the strike, and so this is a lot better than having walk-offs all the time. Like in Britain back in the 50s and 60s, they used to have walk-offs all the time for everything, and we had a better system, and so that's what kept it going and made it effective. I do think it works well also because of the whole grievance procedure. It's not just arbitration. You have the whole grievance procedure. That's why you have you know what's going on in the cases. You can settle them earlier, and I think it doesn't work without a good grievance procedure. You can't go to arbitration all the time. And then on that question of just cause, I would have no fear the American labor movement is going down the wrong alley if they think that they should be afraid of just cause because it'll take away desire for unionization. Everywhere else in the world industrialized world has just cause and almost always higher unionization. Our neighbors to the north, Canada, have a nice predictable just cause system. It's very predictable how much damages you're going to get to. It's reasonable notice. And any starting lawyer I used to calculate this out for my firm. It was like an entry-level job. It's really easy. It's predictable, which is great. Simple. Here's how much you have to pay. You don't spend a bunch on the lawyers. Just give some notice. Here's the compensation. That's it. That does not undercut unions. The reality is unions can offer a lot more than that kind of notice compensation.
Okay. Dave, do you want to comment on that? I do have a question to follow up on your remarks regarding legal fees for you. So let me first see if you've got comments on his, and then I'll ask the legal fee question.
Yeah, very, very quickly. I mean, I agree with Alex that you need a grievance procedure as part of an arbitration, union or non-union. And I think that it's just so ingrained. Why is it popular? It's ingrained. The arbitration procedure in every mature relationship has been established for decades. And I don't think, and Harry, you and I discussed this prior, I don't think that the employee win rate in union arbitration is any higher than it is in non-union arbitration. In terms of, it's not like the employees are winning 50, 60%. They're winning the same 25%. It's just we're more comfortable with it. And so I think we're extending this very good concept to the 94% of the country that's not unionized.
Okay. The fees question, I think picks up a little bit on what Dave said. So let me just ask it of David. And the person's asking, don't you think the lawyer fee structure that exists is part of the problem? And that there's something wrong with the fees that are going to lawyers?
Well, I don't know if it's wrong to pay the people for their work. I mean, I'm a lawyer, and some of my best friends are lawyers, so I really don't want to say that what they do is wrong. And I did do this for a living, and this is what my firm did. So I don't think getting paid for the work is wrong, but I think where the question is right on is the fact that we make decisions based on legal fees is not the best way to make decisions. We settle cases on both sides because the cost in terms of money, time, publicity of getting to the right answer or to the resolution, they're too high to do that. So we settle meritorious cases for way less than they are worth, and we settle frivolous cases for way more than they're worth, all because of the cost of litigation, and that I agree is wrong. Alex,
do you want to comment on that?
Well, the one thing I'd add is that, for for all the kind of distortions and weirdness of the contingency fee arrangement, which is how plaintiffs finance cases, it actually does create a way of financing representation. And this is a really hard problem. How do you finance really independent representation for employees in the absence of unions? Unions do it by dues, and the dues mechanism works well. People complain about paying dues, but the reality is all the studies suggest you get way more in terms of wages and representation than what you're paying. How are you going to finance representation, right? You've got to have some kind of mechanism. We have the contingency fee. It's got weird problems to it, but it's also something that provides more robust representation than you find for non-union employees in many countries. Other countries have tried this and failed at it. It's a hard problem. Okay.
Here's another interesting question. It's about whether there should be written opinions that are required. It's an issue I know we've talked a bit about, because we'd love for Cornell and the Scheinman Institute, along with Kyler, the center Dave directs, to be a repository for written opinions, so we can analyze what's going on, not just because it'll give us something to do research on, but because it would be informative and it would help public policy evolve. But what's your own views about, should there be a requirement for written opinions? And then how do you do that while also wrestling with the confidentiality question? Let me go to Dave first, and then I'll go back to Alan.
I think you absolutely need to require written opinions for two reasons. I think the parties deserve to know what the reason, the rationale for the decision is, or three reasons. The second reason is for the development of the law. Arbitrators, while they aren't generally bound to what other arbitrators say, they want to see what other arbitrators said and why they said it, and the law needs to be developed. And third, in my view of the world on this, the EOC or whatever agency we're putting in charge of litigating needs to be able to look at what's going on in the arbitration world. And if arbitrators are getting something wrong, or there's a new type of case that's being out there that the EOC believes is part of their national enforcement plan, they need to jump on that, and then the written opinions will do it. I don't think it's that difficult to redact the names of the companies and the employees from these written opinions. So I think they can be redacted, and I think they're vital. If we're going to have an arbitration system, we need written opinions.
Yeah,
Alex, you want to comment? Go ahead.
Yeah, I agree on that, and I'll add an additional reason that I think it's really important to be able to use it in the arbitrator selection process, to be able to figure out, is this an arbitrator you want or not? And one of the things I've been most worried about in some of my research is that it does appear to me that the employers are systematically better at selecting arbitrators than the employee representatives. And I think there's a lot of variation in quality on the plaintiff side. There's very good plaintiff attorneys out there who know exactly what they're doing in arbitrator selection. But I find that there's a lot who don't do a lot of cases, or they may be not primarily employment practitioners, and they don't seem to be doing as well in terms of arbitrator selection, and that worries me a lot. And I think written opinions at least help with that. They're easily accessible. You can look at the arbitrator's past decisions in similar cases.
Just as a follow-up to that, what about the issue of credentials for arbitrators? We've talked about lawyers, and we've mentioned litigation, and whether the judges are really good at deciding these opinions. Are either of you bothered by a system that has no formal credentialing requirement, or a requirement that now that they're dealing with employment rights issues on an employment arbitration, that the arbitrator actually knows the law, knows employment law, since many arbitrators traditionally were developed and practiced in the labor management form, where they know a lot about collective bargaining and they know about the law related to collective bargaining, but they may not know a lot about the law related to discrimination or harassment or other issues. So who would like to talk about the issue about, is there a way to sensibly regulate who's an arbitrator in these cases? Alex, go ahead, and then I'll go to Dave.
Yeah, no, that's something that I think we do need to have. I've done some research looking at arbitrators and who are arbitrators and what their backgrounds are. I do think we need something there. Traditionally in labor arbitration, we didn't need credentialing because the union, the management people basically picked the arbitrators enough that a whole cadre of acceptable neutral arbitrators had developed over time. There's a National Academy of Arbitrators, which is the peak organization of the top arbitrators. I think for employment arbitration to work, you need something like that. If it doesn't happen organically, what you do need, I think, is some kind of government agency to be involved. But you need a situation where you can have both employee and employer side representatives in agreement that, okay, this person is good to have in the group of arbitrators, and you need something like that. Credentials help if you don't have a kind of mutual selection process, right? So they could be tied together, but I do think you need something.
Dave?
Yeah, I agree with Alex. And the one slight disagreement is when we look at union arbitration, it's the law of the shop, not the law of the land. Right. And the union arbitrator is bound by a collective bargaining agreement. So she can just look at the collective bargaining agreement and understand the business and read and make the decision. And so we've had it's okay to choose someone who's selectable, who's acceptable to both sides. But we're now talking about the law of the land. And when we're talking about sexual harassment or age discrimination or reasonable accommodations and disabilities, we truly need somebody that understands that, because that's legislative, and we can't have somebody that understands the restaurant industry deciding whether something constitutes sexual harassment or not. So I agree with Alex completely. We need some standards.
So we just have 2 more minutes to go, and we've covered a lot of ground. And I just want to see if there's other issues you think are important that we didn't touch upon, or you want to return to an issue that was raised in our discussion. Let me go to Dave first, and then Alex, if that's okay, in that order.
It's great. Without a lot of time, I guess I'll reiterate that disputes at the workplace are inevitable and arguably healthy. A lot of social justice has come out of workplace disputes. So we know they're going to happen. It's a mix of people with different backgrounds together 8, 10, 12 hours a day. Things happen. Resolution happens. So we know there's going to be disputes. And the concept of sort of the litigation lottery system, where 0.37% go to verdict and make hundreds of thousands or millions of dollars, is not the best way to deal with all of the disputes. So we need a different system, and what we need to do is create something that is accessible and just and provides resolution.
Alex?
So I think you can build a good system. I think you do need, though, to have some underlying source of bargaining power, right? In the unionized workplace, that's the strike. In the non-union workplace, it's litigation. So you at least need to have that threat there to keep the other side honest. But I think when you accept that, I do think there's a lot of common ground for building public policy around a system that's accessible and also does what we really wanted to do, which is to make sure employment rights are being protected. So I do think there's a lot of room for public policy innovation here.
So we have a few more seconds, so let me just ask, and this will have to be sort of your quick knee-jerk reaction. Are we likely to see legislation on this subject of employment arbitration in the Biden administration in the next 4 years? Reading your crystal ball, is it likely, remote, unlikely, and then quickly why? Alex, why don't you go first, then I'll go to Dave.
So it'll all depend on the filibuster. If they get rid of the filibuster, yes. If not, no.
And if they get rid of the filibuster, you think something close to the ban, a ban of some sort,
yes.
A PRO Act type ban, or you think it'll be banned?
Yeah, I think it'll ban. I think it'll be banned in the context of a PRO Act type bill. Yeah.
Okay, Dave, go ahead.
I still don't think that even with you get rid of the filibuster that you'll get Manchin and some of the other more right-leaning Democrats to go that way. So I would argue that if we didn't go 1-0 and we didn't get rid of arbitration but came up with something that incorporated, if you want to do arbitration, it has to do this, this, and this, incorporated what we've all talked about today, then I think you could get the more moderate, I guess, for lack of a better term, Democrats to sign on. But I think in all or nothing, you're going to lose one or two. And then we've had a bill from the Clinton administration all the way through. Obama had 60 senators at one point, and we've never been able, that bill, I think it's Senator Markey, submitted it when he was in Congress, has never gotten any traction. So I think there has to be a middle ground if we want legislation.
Okay. We've covered a lot. You've been terrific, and I thank you. I thank the audience. They've produced a number of really interesting questions and helped deepen our discussion. And I look forward to future venues in which we could deliberate over employment arbitration. Thanks again.